Thank you very much for the invitation. I'm really excited to talk to you all about this book. And also thanks to Nishani for her help, the logistical help in putting this together. So yeah, as Anne said, I'm going to spend time today giving you a little bit of an overview of the book, and also, as Anne said, I think for me, I'm centrally interested in sort of from one perspective, kind of the politics of innovation and the politics of innovation to achieve public interest and social justice goals. I'm also interested in, sort of from a policy perspective, what can we do? How can we better rethink both innovation and innovation policy to achieve those goals? So I'm kind of looking at it both as an STS scholar, but also someone who brings in, how can STS ideas inform better policies is something I spend a lot of time thinking about too. So broadly speaking, this project, which takes you into the micropolitics of the patent system, and hopefully one of the things I hope that this book does is to demonstrate how central and important the patent system is as a site of producing social and political order. We tend to think of it as a technical and esoteric domain, and as I describe in the book, and as I'll talk a little bit about today, that's itself a powerful social construction that we need to analyze and think critically about. But I put that in a broader context of, as I said, innovation and innovation policy and the politics around that, and I sort of come to it thinking broadly about how over the last 30 to 40 years, we've seen a growth in challenges to prevailing innovation logics, let's say, right? So you see this in a variety of different places. You see this in terms of questions about whether or not research funding priorities by governments are in fact actually serving the public interest, whether or not they're improving health outcomes, or are they actually, just serving as a jobs program for scientists, to put it crudely and bluntly. You also see it in terms of questions about what is it that research subjects get out of their participation in these studies. And especially often, right, we know the case of Henrietta Lacks, in which not only was she a research subject, but she gave her tissue and, that created an entire scientific and commercial scientific infrastructure, right? What do the research subjects get out of that? And then finally, we also see it in terms of the reactions to the innovation that we are supposed to be enchanted by, right? All of these wonderful technologies that we are now able to take advantage of that also have, on the flip side, caused or raised questions about risk, about ethics, about distributional dimensions, about unintended consequences, and sometimes maybe simply just consequences that we didn't bother to ask about, and therefore they appear to be unintended consequences. So that's the broad context. I think we see now a lot more civil society discussion around around innovation that that has emerged over the last 40 years, and that's something that, broadly speaking, I've thought about quite a bit and interests me. More specifically within that, and as I began to sort of think about developing this project, in fact, there has specifically been, over the same period, a lot of civil society advocacy around intellectual property, and even more specifically, the patent system, right? So, again, over the last 40 years, there are new kinds of questions arising. I raised these questions already about sort of, implicitly kind of who's the inventor, right? If the taxpayer is giving the money for the production of patentable inventions, if research subjects are giving their tissue, what kind of ownership do they deserve? This is the kind of question that also arises when we're thinking about intellectual property around indigenous or traditional knowledge, which Corey Hayden writes about. But we also see that when we're talking, even in this country, about taxpayers and research subjects and identifying innovation. But we also see a second set of questions around whether or not patents are actually you know, the idea behind patents, and I'll talk a little bit more about this in a second, but the idea is that, you know, we have a patent system, we provide a time-limited monopoly to inventors with the idea that we'll all have access to more technology, that it'll increase innovation, right? But there's also been questions about whether or not patents actually do that, whether they actually increase innovation, whether they actually increase access to healthcare. And then finally, there's a set of questions about what the moral position of the patent system is. Is it by, you know, by offering kind of a government certification, actually providing a moral certification as well? And what does it mean, especially when we're talking about controversial areas of science and technology, whether we're talking about human cloning or these days human germline genetic engineering, is the patent system playing that implicit role? So, and that raises a broader set of questions, I think, that I'll talk a little bit about today, and that I talk about in the book in terms of what the role of the patent system in the is and should be in the governance of emerging science and technology overall. So this is sort of the broad kind of universe within which I wanted to do this study, and I focused the analysis in a couple of ways. The first was to focus on controversies over patents on what are called life forms, so a subset of biotechnology, the kinds of biotechnological products that involve manipulation at the cellular molecular level. So we're talking about stem cells and human genes and genetically modified organisms, plants, animals, and those are case studies, comparative case studies that I discuss throughout the book. And what's important to me about these life form patent controversies and makes it a good place to think more broadly about the politics of the patent system is two things. One is that all of these issues that I just discussed, all of these controversial questions come up in different ways when we're talking about these life form patents, but you see them in other arenas as well, from software patents to pharmaceutical patents. And then finally, the history of these controversies over life form patents are, in fact, they last the entire history of these patent controversies more generally. So, you know, the first controversies over patents were in fact life form patent controversies, and we're still having debates and challenges about that. So that's one reason why I decided to focus the study in that way. And I focused the study on the United States and Europe for a couple of reasons. As Anne said, I'm a comparativist, so I like to think in those ways. I think it, as she so beautifully said, it really allows you to think about science, politics, and values, and it brings those kinds of issues into sharper relief. But, you know, as we know, when we think about the US and Europe, we're thinking about places that we tend to think of as politically and economically similar, certainly as places that have similar capacity when it comes to science and technology. These are also two places that generally we tend to think of as pretty similar, certainly when it comes to intellectual property, and in fact the US and Europe have worked very hard to harmonize, supposedly, their intellectual property systems. So we wouldn't expect significant differences in how they handle life form patent controversies. To the extent that they do, and legal scholars have written about this, they've written about this for a while, they had written about it long before I even started doing research on this book, you know, legal scholars have said, okay, sure, there are some differences between the US and Europe, but those are, of course, they're legal scholars, so they tend to focus on the legal explanation, and they focus on something called the Ordre Publique clause. I'll talk a little bit more about this throughout the talk, but the Ordre Publique clause is a part of European patent law that prohibits inventions deemed contrary to public policy or morality. So legal scholars have long argued that, well, the reason why certain things aren't patentable in Europe and they are in the United States is because Europe has this Ordre Publique clause. So for me, that was unsatisfactory for a couple of reasons. The first is that, in fact, the US has something called the moral utility doctrine. It doesn't come up, nobody talks about it, and that's actually the point that, to me, is interesting for analysis, right? So what is it that makes the Ordre Publique clause something that people use to frame these conversations, when in fact we have something like that in the US, but it never is used, right? So that became kind of a central question that allowed me to go on a much longer kind of historical and political journey through the US and European patent systems. And more broadly, one of the questions that I'm really asking is, what can these controversies tell us about the social and political dimensions of the modern patent system, the innovation policy system, and also highly technical domains even more broadly? So I'm just going to spend a minute talking about the methodology behind the book. I think that's useful, might be useful for some of you. Again, because the vast majority of scholars who think about the patent system are legal scholars. I think having a social scientist look at this, I encourage more social scientists and humanists to do this kind of work. So I think it's important to talk a little bit about the data. So I am an interpretivist, and I do use qualitative methods. So I use the historical record, participant observation, interviews, document analysis to kind of understand and identify social patterns in both the US and Europe. And so I began really by doing the more contemporary analysis. I looked at the recent controversies that I mentioned earlier, and I'll talk a little bit more about in a second, to analyze current controversies. And in particular, I used a couple of things. The first is what are called patent prosecutions. So, as I said, these are legal domains to some degree, and so in legal domains they keep all of the paperwork, and so the US and European patent offices have on file all of the documents that are filed in relation to a patent, and when that patent is controversial, they have all of those documents on file as well. So that includes, for example, letters coming from civil society groups, challenges, etc., and those are incredibly rich. They often run into the thousands of pages if you're talking about really controversial patents, which are long but incredibly fruitful when you're sort of looking at the details. So that's the first thing I looked at. The second was I did over 100 interviews in the US and Europe talking to patent office officials, other kinds of government representatives, activists and other challengers to patents, patent lawyers, other legal scholars and industry representatives. I attended relevant congressional and patent office hearings, meetings, and conferences, and then I looked at other kinds of documents that were being produced around these controversies. But as I did this research, I realized that I needed to also look at these questions in a more historical perspective, because I was sort of struck. I thought that maybe, and I'll say this more explicitly in a second, that there was some historical and political cultural dimension, and so I needed to understand the history a little bit. So then I spent some time doing that historical work. I wouldn't call myself a historian, but there is a historical component to the research. And so I looked at, in both the US and Europe, some historical documents around the evolution of the patent system, around the histories of biotechnology patent law, and that included, for example, in the US, congressional documents, documents around Supreme Court and appellate court hearings, amicus briefs that were filed, etc. So I'm going to foreground the conclusions, and then I'll talk a little bit more about the two cases, or the comparative case, to kind of give you a little bit of a flavor of the kinds of themes in the book. So overall, the sort of main argument in the book is that political culture, ideology, and history shape patent systems, and patents in particular, in fundamental ways. And even more broadly, that we need to reflect on our logics of innovation and to understand that our logics of innovation are deeply political, and they're embedded in particular assumptions about the relationship between innovation and the public interest. And we tend to think, as I've said, and I will say again, that we tend to think about the patent system as highly technical and apolitical, but it isn't that at all. And in fact, this is an important social and political construction that those of us who are interested in policy need to reflect on and reconsider, I think, whether and how that works. So when I say that political culture and ideology shape patent systems, I specifically am talking about the different ideologies in the US and Europe around the relative roles of government and markets when it comes to innovation. So in the book I argue that there are a number of, I would say, there are a number of things going on in both of these places, and of course it's sort of a relatively recent phenomenon to even think about Europe as a thing, but you can see two broad trends. In the US, we tend to think think about the role of government as market making. That is, that the role of the government is to make the marketplace, and that moral decisions are made by market players, producers and consumers, but that's not really the role of government. By contrast, in the European context, I argue, there's more of a market shaping ideology, that part of the role of government is to enforce a broader moral order when it comes to innovation. And those broad differences in ideology then have very specific implications for the political machineries of the US and European patent systems. And what I show in the book is that you have these different understandings of patent systems, more specifically of patents. Patents in the US tend to be defined as techno-legal objects, whereas in Europe they tend to be defined as moral and socioeconomic objects. But then these have attendant implications for political order. They shape how the two places think about the role of the patent system as part of the overall apparatus for governing science and technology. They shape the kinds of debates that take place, the participants in those debates, the avenues for participation, as well as how those two systems understand what constitutes relevant expertise and evidence for policymakers. And then finally, different understandings of the public interest. And one of the things that I won't have an opportunity to highlight today, but I talk about in the book, and I specifically talk about it around the gene patent cases, and I'm happy to talk about that in the questions if you'd like, is that, you'll see in the cases that I talk about today, differences in framing and sort of the issues of debate. But one of the things that I find incredibly interesting is sort of even the extent to which the patent system has anything to do with moral or socioeconomic implications is something that is, fought really hard in the US, right? So the idea, for example, that there's such a phenomenon as a patent-based monopoly that might have some distributive implications is something in the US that we tend to say, no, it doesn't have those kinds of implications. It's just an administrative law domain, for example. Okay, so let me get into the meat of the book a little bit and give you a sense of its trajectory. So I'm going to start with a broad brush of the history, the extent to which I think I want you to know a little bit about before I get into the more contemporary cases. And as I suggested, I think that there's a historical component to the differences between the US and Europe. Now, patent systems have been around since the 15th and 16th centuries in Venice and England, and at those stages there were, it didn't look like the modern system that we know today, but it had some of the precursors, and in some of those early systems, in fact in the English system, there was some concern that patent monopolies were in fact causing some public problems, and in particular at that moment, the sort of version of patents that we know of from 1623, for example, is that patents were causing problems because you could have kind of a patent, an infinite term for a patent, and so people wouldn't be able to get access to daily necessities, and this was causing riots and public disorder. And I didn't choose the year 1623 out of the air. 1623 is the year of the first patent law, the English Statute of Monopolies, and that's a significant date because in that patent law there's language around how they're going to prohibit patents that might cause riots or public disorder. So that's in fact the first moment where you see kind of some kind of public interest consideration explicitly finding its way into patent law. By the sort of 18th century into the 19th century, both the US and France start to develop what we now recognize as the modern patent system that rewards inventors for a limited period of time for their invention if it reaches a certain threshold of inventorship. But even though the US and France are developing somewhat similar approaches, there are even then some, I think, significant differences. And one of them is that the French, and then even more generally other European countries, are carving out spaces where they think the patent system shouldn't go. And one of those significant places places is food and pharmaceuticals. So in the 19th century, there are bans in many European countries on patents for food and pharmaceuticals. And then by the 19th and into the early 20th century, you know, they kind of weaken those laws a little bit, but they create what are called compulsory licensing rules, legislation, that allows the government to step in if a patent holder is not actually exercising their patent, to make sure that it is available and that an important technology is available to the public. So the point that I want to make, you know, here, and the reason that it's important to the broader argument, is that the government is seen as playing an important role in performing a balancing act between public interests and the inventor's interests, or public interests and private interests. And that role, you'll see, is sort of conceptualized quite differently in the history of the US system. And in the 1970s, a pan-European system comes into being, and it kind of reflects this basic approach. There are a number of clauses in the European patent law that kind of takes this attention and takes this responsibility of government pretty seriously. In the US context, there are, you know, as I said, there's a somewhat similar history, but there are a couple of things that I just want to draw out for today's conversation that I think are important in comparative perspective. And the first is, I mentioned, right, that in a number of European countries there are a number of carve-outs to patent law. There aren't those same kinds of things in the US. The second thing that is important to keep in mind is that at the same time that European countries were passing this compulsory licensing legislation, there was discussion about it in the United States, but there was massive opposition to that kind of law. And in fact, in those congressional hearings, you see Congress people saying, you know, that patent holders are in fact morally responsible actors, that they're never going to actually make it difficult for someone to get access to something. So you have, you know, on occasion you have military officials and public health officials saying, wait a second, you know, there are these places we're a little bit worried that we're not going to have access to the right drugs, you know, pharmaceuticals on the battlefield, and you know, the patent lawyers and policymakers are saying, no, you don't have to worry about that. You know, these patent holders, these inventors are going to take care of us. So that is a clear demonstration of a broader phenomenon that I see in the United States, which is that we see the public's interest as essentially synonymous with the inventor's interest. And there are other, you know, pieces of data that I've used to kind of demonstrate that. Another, I think, clear example of this is, you know, Mario Biagioli, who many of you probably know, talks about the democratization of invention. He talks about how when the US develops its patent laws, they make sure that application fees are kept low, that there are public displays of patented inventions at museums, and that the idea behind this is to make sure that anyone can access the patent system. The flip side of thinking about that, of course, is also assuming that everyone is a prospective inventor, right? Everyone wants to participate if they could do so, and so we need to make a system, we need to make a set of laws and an infrastructure that will facilitate that. That, of course, that idea that then the public and the inventor's interests are essentially synonymous, you know, has effects that we see, I think, still today. The second point that I want to make about the history of the US system, and this is something that we see elsewhere in US regulation, especially in technical areas, is the emphasis on procedural objectivity. So, you know, a lot of the work, especially comparative work on risk regulation, talks about how procedural objectivity, that is, demonstrating that, you know, the bureaucrats are thinking in objective ways only according to science and the law, that is in fact the way in which they enact democratic values, right? That objectivity is the way in which one can demonstrate that you know, they're making decisions without bias, that they're transparent in their operations, and you see this in the way that the patent system is structured as well. So now I'm going to fast forward a little bit to the kind of meat of the substance of the book, and that is to focus on the history of life-form patents. So in the 1970s, a set of questions arises as there's increasing excitement about biotechnology, right? We're creating these new kinds of, objects that could be seen as nature, that could be seen as technology, that could be seen as life, could be seen as not life, and that raises a series of questions. It is, the fundamental question is whether or not these things are patentable, and then the knock-on questions are they discoveries or inventions? Are they life or not? Are they nature or technology? And those are questions that, we've seen scholars, as I said, mostly legal scholars, but we've seen scholars address in a variety of different ways over the years. But the focus that I want to take, and that I do take in the book, is to focus on the political questions, right? So who is making these decisions? Who do we think in these moments should be making these decisions? What kinds of evidence and expertise do we deem relevant to these conversations? And how do we understand the role of the patent system in the history of governing biotechnology more broadly? And here is where you see one important, sort of an initial important comparative difference in the history of biotech patent law. And the first, and what we see is that in the US, immediately the conversation is compartmentalized. The question is treated as a narrow legal question, as well as a question about whether or not life forms are nature or technology. So the question arises in the context of a genetically engineered microorganism designed to eat oil, created by a scientist, Ananda Chakrabarty, at General Electric, and it goes eventually through the Supreme Court. And at the Supreme Court, it's generally a pretty standard procedure. You have amicus briefs. 14 out of those 15 amicus briefs come from universities, including the one I'm standing at today, biotechnology companies, patent lawyers, etc. And then you have one amicus brief that comes from a civil society coalition led by Jeremy Rifkin, now well known as a biotechnology watchdog. And his amicus briefs looks like nothing that you've seen before in the context of the patent system. He's raising ethical questions, socioeconomic questions, he's citing philosophers, he's citing environmental, he's citing National Academy's reports about the environmental implications of genetically modified crops. He's asking questions about whether or not patents on life forms are going to create a certain kind of commodification that will have serious moral implications. However, the court kind of dismisses these questions, and the court and the other amicus briefs essentially say, you don't really understand what's going on. This is a very narrow question, and the majority opinion says, this is really just about research. It may determine whether research efforts are accelerated by the hope of reward or slowed by want of incentives, but that's all. It's not about all of these other issues that you're raising. The story in the European context couldn't really be much different, and I think it raises a number of questions for how we understand the US story. So the history in Europe starts a little bit later. They know that the Chakrabarty case has been decided in the US, and the European biotech industry is clamoring for some clarity about what is actually patentable in Europe. And they ask the European Commission to come up with a piece of legislation that will make it clear across Europe what the story is when it comes to biotech patent law. And so the European Commission drafts a proposal, it sends it to the European Parliament, the European Parliament sends it to a set of interest groups, which is sort of customary in the way that they do legislative review, and immediately that set of interest groups, which includes farmers and breeders and labor unions and religious groups, says, wait a second, this is being treated as a technical question. It's not a technical question, it's a moral question, it's a socioeconomic question, it could have major implications for healthcare and agriculture and European morality, and we need to deal with all of these things. So Parliament, takes this report. They have a number of committees look at that report. Those committees create their own reports, and then civil society groups get involved, and all in all, it takes 10 years of deliberation. And in the end, the 1998 European Biotech Patent Directive includes a number of concessions or limitations when it comes to biotech patents. So it reaffirms an experimental use exemption, which allows scientists to do research on patents without fear of interfering with a patent. There's a farmer's privilege that allows farmers to save seed across generations. There are a number of exclusions according to bioethical concerns around human and animal dignity. There's a weighing up test, for example, around that requires animal patents to be weighing the suffering to the animal against the benefit to humankind. And there's also a provision that prevents patents that involve the commercialization or exploitation of a human embryo. So one of the points that I talk about more in more detail in the book, but I'm not going to spend too much time on it now, I'm happy to talk about it more in the questions, is that this is the moment, I argue, that actually the Ordre Publique clause takes on this bioethical meaning, right? So I talked a little bit about riots and public disorder, right, along, in the 1600s, but the Ordre Publique clause actually turns into this modern bioethics clause. It wasn't actually the thing that legal scholars have argued it was all along. But it takes on this meaning, and this European law now has this embedded in it. And the broad point, of course, is that the question, right, what kind of question is the patentability of life forms and who should be involved, is treated very differently in these two places that supposedly have very similar patent systems, right? So that's the sort of high level argument. So at this point, on some level it kind of creates some clarity, but there's a whole history of biotechnology to come. And so the next set of debates is around animal patents. And in the US and in Europe, you have controversies around the patentability of genetically engineered animals. In the book, I talk about how essentially what happens is that in the US, civil society groups, now you have, that first set of groups, but also you have environmentalists and farmers and animal rights groups getting involved and challenging the patentability of animals, concerned about, sanctioning controversial areas of research, about the moral dimensions, about the implications for agriculture. And they do so in Congress, in the courts, at the patent office. So they're trying, multiple, I call it the Goldilocks strategy, right? They're trying multiple venues. But the U.S. asserts what I call expertise barriers, which are formal and informal rules that develop over the course of a policy domain's history, but are shaped by political culture and ideology, and it's sort of shaping who can participate and how they can do so and what constitutes relevant evidence and expertise. And in the context of animal patents, this is where you see, rhetorical language about how these challengers don't understand the system. They don't have the requisite knowledge. They're ignorant of how it works, and therefore they can't participate, as well as other kinds of more structural barriers that prevent these outsiders from participating. By contrast, in the European context, there is more of a attempt to wrestle with these challengers. So what the European civil society challengers, and at this point they're kind of analogs, they're similar types of groups in the European context, and they actually take advantage of a clause in European patent law called the opposition mechanism, which allows anyone to challenge a patent within 9 months of its issue on any grounds. And so they use that opposition mechanism, and they've used it many, many times since. It's now become a well-worn civil society strategy to trying to force the patent office to consider their concerns. And remember, we're talking about the patent office, right? So the patent bureaucracy, a highly technical and legal space. And so one would imagine that this would be the most hostile potential place you could imagine for this kind of challenge. And yet, the European Patent Office, at first they kind of, they're sort of taken aback by the fact that these people are there. They don't know what to do, but they allow them in. And I talk in the book about how similar efforts in the U.S. are stymied at every turn, but in Europe, at the European Patent Office, these challengers allowed in. And then the European Patent Office, in this case, has to figure out how to manage these new participants, how to manage the different forms of evidence and expertise that they're bringing in, which are often forcing them to think differently with different kinds of resources than they've been accustomed to before, because traditionally we tend to think of patents as being judged on the basis of scientific prior art, i.e. scientific publications and patents, or legal precedent. But a lot of these civil society groups who are trying to, shape how the European Patent Office is conducting that weighing up test that I mentioned earlier, they're bringing in medical evidence about animal suffering, right? They're bringing in ethical, efforts to think about how to engage in ethical reasoning. So there's a struggle at that point to figure out how to do it. Eventually, the European Patent Office focuses on, as I said, this opposition mechanism is focused on the oncomouse patent. You see, oh my, I didn't notice that this hadn't changed. Sorry. I don't know what to do about it, but anyway. I have lots of slides with pictures. I hadn't even looked over there.
It changed, yeah.
Oh. Had you seen any of these slides?
No.
Well, that's too bad. I'm just going to keep going. Here's the oncomouse patent. This is actually a postcard from Greenpeace trying to get average citizens, to send these postcards into the European Patent Office as a mode of civil society challenge. And so they challenge the oncomouse patent. The oncomouse patent, as written, is very broad. It covers any animal genetically engineered to contract cancer. And in Europe, it gets narrowed significantly in the end after a lot of this debate, and it ultimately is focused only on a mouse genetically engineered to contract cancer. Whereas in the US context, the similar patent was issued, and it was issued in a broad, with a broad scope. So I'm just sort of pulling out, there's a lot of this kind of data in the book, and I'm not, obviously I don't have time to talk about that here, but I thought that putting these two quotes next to each other, for me, really illustrates the differences in the emerging differences between these two places. So the US quote comes from a former commissioner at the US Patent Office when he was being confronted with a patent that Jeremy Rifkin and a developmental biologist by the name of Stuart Newman filed on a human-animal chimera. And they wanted to force the patent office to really consider the question of the patentability of animals and humans, and how is it exactly that the patent office had defined human being, and they were trying to force the patent office to think about the moral consequences of the decisions that they were making. The patent office had said, we won't allow patents on human beings, but of course in an age of biotechnology, that's a remarkably non-specific statement, right? So the PTO commissioner, this goes on for a while. Eventually Newman and Rifkin, kind of give up after a lot of back and forth with the patent office. But what's striking to me is that the response essentially was, that the problem here was that these people who don't belong are participating in this system, right? The commissioner says, it's not that I don't believe there should be a prohibition against a human patent. I was just deeply offended by anyone attempting to use the US Patent Office to make a point or to stop the advancement of science. I refuse to make it easy for them, right? So it's not a space for, a certain kind of democratic engagement, right? This is not a liberal space. Only the appropriate participants can be here. By contrast, a communications official at the EPO says, when the oncomouse Harvard patent was granted in 1992, a big storm arose that nearly swept away the EPO because people were so strongly inward looking at this place that they didn't realize what was going on, that the work that they were doing was not just considered to be of relevance to pharmaceutical companies and other innovators, but there was a strongly social component to the patents as well. I told the opposition opposition division straight away. This is not an opposition hearing, a normal one that you get in inter partes procedure. And what he means by that is, it's not the usual, these opposition mechanisms weren't meant for this kind of conversation. They were meant for fights between industrial competitors, right? This is going to be turned into a tribunal against the EPO, he says. What you're doing is wrong. You're not paying attention to the people. You're not seeing the political and social dimension of this patenting process. This patent is a contract between a private investor, someone who's got a private interest in obtaining a patent, and society. You are mediating this, and you're in the middle of it. And if you're not doing the job properly, you're going to get some feedback. And this communications official told me an interesting story about how at that Oncomouse hearing, right, they were, the EPO officials were negotiating with the inventor about how they could narrow their patent in a way that the EPO would accept. And as they were trying to do that, which is completely customary, all of the audience, and they had all of these civil society activists in the room, which they weren't accustomed to, but those civil society representatives started to boo and hiss because to them this was a deeply biased process, right? So to them this is this other moment, right, where the sort of the way in which they're thinking about the public interest is being challenged essentially, right? Because by this other public who's all of a sudden sitting there and saying, no, the way you understand the public is not right. So I'm going to just spend a couple of minutes talking about one of the comparative cases later in the book to give you a flavor of another dimension of the analysis, and that is to focus on human embryonic stem cells, and of course there's an interesting dimension, an interesting California dimension of it too. So as many of you probably know, in the 1990s and into the early 2000s, there was enormous excitement about the promise of human embryonic stem cell research, and there were researchers in the US as well as in Europe doing this kind of work. And in the US, the first human embryonic stem cell patents were issued to scientists at University of Wisconsin who had isolated initially primate embryonic stem cells and then human embryonic stem cells. And the University of Wisconsin patents were then licensed to biotechnology company Geron. And also, of course, many of you will remember that this is also a moment of great anxiety about human embryonic stem cell research, right? There's great excitement, but there's also concern because George W. Bush comes into office. One of his first acts is to restrict the lines, the stem cell lines that are available for federal funding. He restricts it to lines that had already been created, so it wouldn't involve any further destruction of human embryos. So there's concern about whether or not stem cell researchers will be able to have complete freedom in doing their work. And so that is happening at the same time that there starts to be concern in the US about whether or how widely Geron is going to license their patents. And so the debate in the US around stem cell patents is framed almost entirely around a right to research. And as I said, you hear that to some degree in the discussion about research funding, but that's the piece of the conversation that you see in the patent system as well. The interesting thing to me, and it is also, again, as I'll say in a minute, interesting in comparative perspective, is that the early concerns about commodification through patents, right? So the moral concerns, the idea that you're producing ownership in living things, that this changes, what it means to be human, is entirely absent from the debate, entirely absent from the conversation about intellectual property. And that's particularly weird given that the debate about human embryonic stem cell research is centrally about the moral questions, right? But those questions don't come into the patent debate. And what's also interesting is that a lot of the people who've been involved in the first generation of Lifeform patent debates or are discussing these issues in other part of the stem cell debate are only focusing on right to research questions when it comes to the patent system. So one of the points I want to make here is that this history, these expertise barriers, the way this domain has been framed, is then transforming the political environment. It's transforming the terms of debate, and it's also transforming the kinds of participants that you see in this debate. So those people that are concerned primarily about the moral dimensions, the commodification dimensions, are no longer really part of this conversation. During the this period, as you all probably know, California establishes the Institute for Regenerative Medicine with a $5 million bond. They create an intellectual property task force, and this is seen at the time as potentially very interesting. The idea is that, now California may be producing a lot of intellectual property, and because it is doing so, perhaps it should think in a creative new way about what to do about this intellectual property. And they issue a report, this task force issues a report, and in which they try to establish a research exemption addressing this right to research concern, as well as special healthcare access provisions. In particular, they say, since our taxpayers are paying for the California Institute for Regenerative Medicine, then they should not have to pay full freight for any kinds of therapies that come out of it. The response is swift and strong from the legal community, the biotechnology community, and to some degree the scientific community, who basically say, again, reasserting these expertise barriers, you don't understand, this is very complicated, sure, there may be some concerns about a right to research, but is it really worth throwing the baby out with the bathwater? We need to do a lot more study. And what's interesting is that task force, which included patient advocates and scientists and healthcare professionals, almost immediately kind of recoils and say, "Oh no, you're right. It's too much for us to make this major change. We should wait and think about it." Eventually, those stem cell patents are amended after a patent office process in which they allow. The patent office will look at patents if there's a question about whether or not the patent office made a technical error, and that's an important point, and it's called re-examination. And so the patents are eventually amended, but as I said, what's interesting to me is both that this debate excludes the discussions that are emerging, which are around social and ethical implications, but also that it sort of reaffirms this idea that, we should be trusting the patent holders centrally, right? That they have a moral responsibility, they should be trusted to wield that moral responsibility appropriately. They're working in the public interest. So the European analog starts somewhat similarly around basically the same time. The European Patent Office grants primate embryonic stem cell patents initially, but they are very broad in scope. They include humans. They also actually include, if you look at the technical language, transgenic humans as well. And so civil society groups, many of whom had been involved in these earlier cases, find out about this patent, they file an official opposition, they tell the press, and the University of Edinburgh initially, basically kind of poo-poos these challengers and says, stem cell research is revolutionary, it could have these enormous benefits for humankind, there's no moral problem here. Civil society groups respond, as well as the European Patent Office, saying, no, there are some very serious ordre public questions, and in particular, this language that I mentioned earlier, which is that the European patent law now says that they will not allow patents on inventions that involve the commercialization or exploitation of a human embryo, is explicitly, is central to a discussion about human embryonic stem cell patentability. Meanwhile, the European Parliament gets involved too, and they issue a non-binding resolution, but a resolution that, while non-binding, I think in its text is incredibly interesting for a number of reasons when you're thinking about, how this domain sees its role, which is that they condemn the decision by the European Patent Office to allow this patent, and they question whether the EPO is publicly accountable, noting that no consideration of research, and still less of profit, can be allowed to override that of the dignity of human life. So there are a couple of things that are interesting to me about this. The first is, I mentioned earlier this idea of procedural objectivity, the focus on technical and legal dimensions of how patent offices work, as being central to the way that patent offices generate and maintain their legitimacy, their political legitimacy. And that's certainly still the case in the United States. But in the European context, over the period of the debates over biotechnology, you see a new idea about what it means to be publicly legitimate and appropriately accountable in a democracy. It's no longer adequate to be procedurally objective. It is now also required to be responsive, essentially, representative and responsive of public concern. So that's I think, an important point. And the second is that the focus, and this doesn't necessarily come out here, but one of the things that's very interesting to me is that the focus is not so much on sanctity of human life, which is the focus in the US research debate. It's about, you know, dignity that might be diminished through commercialization. So the concern is really about commodification and commercialization, and less, you know, it's not so much that you have pro-life groups generating these concerns in Europe. It's actually it's a really different dynamic. There are some pro-life groups involved, but the vast majority of challengers are not, in fact, pro-life groups. So the EPO ultimately rules that human embryonic stem cells are contrary to the Ordre Publique clause and unpatentable. The European Court of Justice eventually agrees on another related case, and so stem cells, human embryonic stem cells, are deemed unpatentable in Europe. Meanwhile, European patent system institutions are taking on ethical and socioeconomic concerns in a variety of other ways. So the European Patent Office tries in multiple ways to sensitize its examiners to ethical and socioeconomic concerns, and that's something I'm happy to talk about a little bit more in the question period. National governments and the European Parliament try to kind of make compulsory licensing legislation more specific and update it for the 21st century. So there are a number of efforts elsewhere to kind of, you know, think about what the potential broad implications are of the patent system and to address those proactively in the system. So I'm going to wrap up with a couple of final slides, and the first is just, you know, obviously this is a busy slide, and I'm not sure that you can see the detail, but the point is that two systems that we again tend to think of as really similar, and even one would still argue, I would also argue that patent law largely, I mean, I talked to the human embryonic stem cell case, but there are more similarities in patent law and patentability between the US and Europe than there are differences, without a doubt. But the important point to me anyway, as someone who thinks about politics and policy, is that different political orders are being constructed, and different ideas about the role of the patent system in governing science and technology are being constructed. That in the United States, patents are understood as techno-legal objects, as I said, as having a limited impact on society only in terms of increasing innovation and economic growth. That public interest is seen as largely the same as inventors' interests. That the role of the patent system is really separate from other policy arenas, and the PTO is seen as a very limited bureaucracy. That evidence and expertise are seen as pretty narrow, as legal precedent, scientific prior art, to some degree market experience. In the California case, for example, the biotech industry basically said to the task force, no, we have industrial experience, that's why you should listen to us. There's a narrow scope in terms of who should participate beyond that, certainly not civil society groups. And that the kinds of questions that are acceptable are questions around patentability, but also to some degree questions about whether or not patents stifle innovation. By contrast, in the European context, you have patents that are defined as moral and socioeconomic, which of course then means that you are having debates about whether or not patents are moral, what is the moral role of the patent system, do patents potentially have negative moral or distributional implications, and that with it comes different ideas, obviously, about who's an expert, what kind of evidence is relevant, who is a participant, what kinds of avenues of participation are appropriate, and more broadly about the role of the patent system in governing emerging science and technology. So in the European context, I would argue that the patent system is seen as part of a broader regulatory apparatus, and the EPO is really seen as a policy organization. So then finally, right, as I said, that for me, all of these differences come back to fundamental differences related to political culture, ideology, and history. What I try to do in the book is to show how those, kind of cultural differences are essentially enabled rhetorically and structurally through political machineries that kind of hold those differences essentially in place and perpetuate them. And so then I'm going to sort of switch hats a little bit and think about, okay, so if the way we think about patent systems, the way we construct patent systems as technical, as amoral, or as moral or socioeconomic are entirely sort of the product of these kinds of political machineries, then it allows us, I think, to at least start to ask the question about the potential role of the patent system in governing emerging technologies, right? Are we thinking in too limited a capacity about the role of the patent system? And obviously, we see that patent systems see technical arenas at earlier stages of development that allows them to be potentially more proactive than we tend to think about patent systems. It can, and therefore, it can help us potentially anticipate where and how distributional concerns might arise, something that is increasingly a concern, right? We hear now about drug pricing discussions, but of course this would require us to think really differently about what constitutes relevant evidence and expertise, the kinds of pieces of evidence that we tend to not think about, right? How many people do not have access to something because of the price of the drug? How much benefit does a new patented compound provide in relation to the generic? How should that change the way we look at patent law and policy? And it can also obviously help us flag public and moral concerns, I would argue, somewhat earlier. And my hope is that more generally that this kind of analysis forces us at least a little bit to reflect on the ways in which the way we frame debates about emerging technologies might be actually itself conditioned by our broader political environments, and what are we missing? For me, that's one of the things that comparative work can do. Obviously, though, as a good comparativist, you have to think about what would work in a particular context. One of the things that's really interesting to me is that there's been recently a lot of discussion about ethical licensing, particularly around CRISPR-Cas9 technology. And what this means is that the Broad Institute, who is instituting this, have a number of limitations to the licenses that they'll offer. So they say you can't use this for human germline genetic engineering, you can't create gene drives, there are a number of different stipulations. And I think that that's interesting. On the one hand, it fits within our cultural approach, which is to trust the moral authority of market players. On the other hand, of course, there are questions about whether, what made the Broad Institute do it in this case and not in another case. We're trusting a market player, which means there's limited transparency about this decision making. And these are the kinds of things that, we should, at least in theory, think is the role of the government. And so that, I think, raises a question about whether we should be content to let market players do this kind of work. But there are broader questions, I think, about other places that are lacking now in terms of the governance of emerging science and technology, where we might be able to see explicit attention to the ethical and socioeconomic dimensions of technology broadly, but intellectual property rights more specifically. So I'll stop there and take questions.